At my birthday dinner, my 7-year-old kid called me useless father. Everyone was shocked. He said, "Dad, that is what Mummy used to call you when she's on the phone." My wife and everyone laughed so hard they cried. I just smiled and left. That night, I changed the locks, canceled her company loan payment. At 8:09 Alpha.mu, her company, cars, everything was gone. And then, you know what they say about the best laid plans of mice and hedge fund managers? They all go to shit the moment a 7-year-old opens his mouth at your 42nd birthday dinner. But I'm getting ahead of myself. The venue cost me 48 grand for the night. Not because I'm an idiot with money, but because Maya insisted we make a statement. What kind of statement requires gold-leafed napkins and a live jazz trio that probably graduated from Juilliard? I'll never know. But when your wife runs a legal tech startup that's burning through series of funding faster than a Tesla burns through battery on the FDR, and she's still convinced she's the next unicorn CEO, you learn to pick your battles. This wasn't one of them. The River Club sits perched above the East River like some old money fever dream, all mahogany and marble, and the kind of understated elegance that screams, we don't need to prove anything to anybody. The terrace overlooked the water like a goddamn postcard. You know, the kind tourists buy and never send. Soft amber lighting that cost more per bulb than most people spend on groceries, reflecting off crystal that probably had its own insurance policy. I'd chosen my midnight Tom Ford suit carefully, the one that makes me look like I could buy and sell half the room without checking my portfolio balance. Which, to be fair, I probably could. Harbor Ridge Capital wasn't built by accident, and my position as managing partner meant I'd spent the last 15 years turning other people's anxiety into my assets. Tonight, though, the suit felt like armor, and I was starting to suspect I'd need it. The guest list read like a who's who of Manhattan's legal and financial elite. Maya's law school buddies from Columbia, all of whom had somehow failed upward into white shoe firms or in-house counsel positions at Fortune 500s. My in-laws, Richard and Patricia Sterling, who never quite forgave me for not inheriting my wealth instead of earning it. A smattering of venture capital partners who spoke in buzzwords and measured success in terms of disruption and market penetration. The kind of crowd that discussed compliance frameworks over oysters and debated the merits of different LLM architectures between the soup course and the fish. I should have been relaxed. The Macallan 25 flowing like water should have helped. The fact that Verdict AI had just closed a bridge round that would keep them solvent for another 18 months should have been cause for celebration. Hell, even the board meeting earlier that week had gone smoothly. No hostile takeover attempts, no shareholder revolts, just the usual dance of corporate governance and fiduciary responsibility. But there I was, checking my phone every 5 minutes for urgent emails from my CFO about our latest acquisition, trying to smile and nod while Graham Whitfield from Whitfield Capital explained why his fund's approach to due diligence was more holistic than traditional private equity models. The man talked about leveraged buyouts the way other people discussed their golf handicaps, with enough technical detail to sound impressive and enough vagueness to avoid any real accountability. "Julian, you're being awfully quiet tonight," Patricia Sterling observed, her voice carrying that particular brand of passive-aggressive concern that comes standard with Upper East Side matriarchy. "I hope the pressures of managing such a large portfolio aren't weighing on you." Before I could formulate a response that wouldn't end with me explaining the difference between assets under management and actual net worth, my son Theo decided to take center stage. 7 years old, all elbows and energy, climbing onto his chair like he was scaling Everest. The kid had his mother's dark eyes and my stubborn streak, a combination that usually meant trouble was brewing. He grabbed his water glass, which in this place was probably Waterford crystal worth more than most people's rent, and started tapping it with his dessert spoon. The metallic chime cut through the ambient jazz and forced conversation like a judge's gavel. Conversations died. Forks paused mid-bite. Even the waiter, who'd probably seen every conceivable dinner party disaster in his career, stopped polishing glasses behind the bar. "I want to make a toast," Theo announced, his voice carrying that confidence that only comes from being 7 and believing the world exists for your entertainment. Maya beamed, probably thinking this was some sweet moment she'd post on her LinkedIn later with hashtags about work-life balance and raising the next generation of leaders. Richard Sterling chuckled and muttered something about chip off the old block. The VC crowd looked charmed. Nothing like a precocious child to remind them why they're grinding toward that next fundraise. Happy birthday, useless father. The words landed like a compliance violation in an SEC audit. Clean, precise, and absolutely devastating. The silence stretched for exactly 3 seconds. Long enough for every person at that table to process what they'd just heard. Long enough for me to feel my carefully constructed evening crumble like a poorly structured derivative. Then Theo, bless his completely oblivious heart, decided to explain. Dad, that's what Mummy calls you when she's on the phone with Uncle Graham. Uncle Graham. I turned to look at Graham Whitfield, who suddenly found his braised short ribs incredibly fascinating. The same Graham who'd been pitching me investment opportunities for the past 6 months. The same Graham who'd been advising Maya on Verdict AI's growth strategy. The same Graham whose private jet photos on Instagram always seemed to feature an extra champagne glass. The laughter started small, a nervous giggle from someone's wife who didn't know how else to process the moment. Then Maya herself started laughing. That bright, performative sound she made during board presentations when someone asked uncomfortable questions about burn rate. Her Columbia crew joined in, because what else do you do when your friend's marriage implodes over the appetizer course? Even Richard Sterling was chuckling, probably thinking this was the kind of family drama that would make for great conversation at the yacht club. But I wasn't performing. I wasn't pleading. I wasn't doing that thing where you laugh along to show you're a good sport. Even while your wife's emotional affair gets broadcast to Manhattan's legal and financial elite by your own kid. I smiled. The same smile I use when a deal goes sideways and everyone's looking to me to fix it. Calm, controlled, completely empty of anything resembling warmth. I stood up, the Tom Ford suit suddenly feeling less like armor and more like a uniform. I leaned down and kissed the top of Theo's head, right there in front of everyone, because none of this was his fault. Make a wish on the candles, buddy, I whispered. Daddy's got to take a phone call. I walked out of that $48,000 venue with the birthday candles still burning, past the live trio, playing something appropriately melancholy, past the waitstaff who were definitely going to have a story to tell their families later. Through the floor-to-ceiling windows, I could see them still laughing, Maya gesturing animatedly while explaining something to the table, probably spinning this into some anecdote about men and their fragile egos. The Tesla Model S was waiting at the curb, my driver holding the door like nothing had changed. But everything had changed. In the span of 30 seconds, a 7-year-old had delivered the kind of information that would have taken a team of forensic accountants weeks to uncover. My marriage wasn't failing because of the usual suspects: work stress, different priorities, the general entropy that kills most relationships in our tax bracket. It was ending because my wife of 8 years thought I was useless, and she'd been discussing that opinion with a venture capital partner who had a history of acquiring undervalued assets. As we pulled away from the River Club, I looked back through the tinted glass one last time. They were still laughing, still performing, still pretending that what had just happened was amusing instead of devastating. Maya was probably already crafting the narrative. How Julian couldn't handle a little joke. How successful men are so fragile. How she was the real entrepreneur in the family anyway. But here's the thing about being useless. It's all about perspective. To Maya and her audience tonight, I might be the boring money guy who signs the checks and attends the board meetings. To them, I'm probably just another suit in a world full of suits, lacking the vision and creativity to build something that matters. What they don't understand is that useless men don't build portfolios worth 9 figures. Useless men don't structure deals that keep legal tech startups alive when their burn rates exceed their revenue projections. And useless men definitely don't have the kind of contractual protections and corporate structure that can turn a humiliating dinner party into a very expensive lesson about the difference between equity and control. The driver asked where we were headed, and I gave him our address on the Upper West Side. The penthouse I bought 3 years before Maya and I got married, held in a trust structure that my attorney had insisted on back when I thought prenups were just good business practice instead of emotional life insurance. That was the exact moment my marriage ended. Not with papers or lawyers or mediation sessions, but with a 7-year-old's toast and the sound of laughter that didn't include me. Everything that came after was just paperwork. The thing about Manhattan penthouses is they're supposed to make you feel like you're on top of the world. Tonight, staring out at the city from 30 floors up, all I felt was the quiet satisfaction of a man who'd finally stopped pretending his marriage was worth saving. The Upper West Side sprawled below me like a circuit board, all glittering lights and orderly patterns, each window representing someone else's life, someone else's problems, someone else's illusions about what really matters. I poured 3 fingers of Macallan 25, the good stuff, not the bottle I keep for impressing clients who wouldn't know single malt from paint thinner. This was the bottle I'd been saving for special occasions, and apparently discovering your wife thinks you're useless qualified. The amber liquid caught the light from the city below, and I took a moment to appreciate the irony. Here I was, in a penthouse I'd bought outright before Maya and I even got engaged, drinking whiskey that cost more than most people's monthly rent, about to systematically dismantle the life of the woman who'd spent the evening laughing at my humiliation. The penthouse wasn't just real estate, it was strategy. When I'd bought it 7 years ago, my attorney had insisted on holding it through a Delaware trust structure, with me as the sole trustee and beneficiary. Separate property, she'd called it, explaining how New York's equitable distribution laws worked. At the time, I thought she was being paranoid. Tonight, I was grateful for her paranoia. I pulled out my phone and started making calls. First, the building manager, a guy named Santos who ran the place like a military operation and asked no questions as long as the checks cleared. Santos, I need the locks changed. Smart lock codes first thing in the morning, physical cylinders by 8 a.m. Full reset, new access protocols. Everything okay, Mr. Harper? Just some routine security updates. I'll forward you the new access list tomorrow. He didn't ask who wasn't going to be on that list. That's why I paid him enough to afford his own place in Queens and send his daughter to private school. Discretion was part of the service. Next call went to Amara Okoye, my attorney. Harvard Law, 10 years at Cravath, specializing in both high-stakes litigation and the kind of corporate work that keeps Fortune 500 CEOs sleeping soundly. She'd left Big Law 3 years ago to start her own boutique firm, taking me and half her client list with her. At 11:30 p.m., I knew she'd be awake. Lawyers at her level don't keep bankers' hours, especially not when they're building their own equity stake in a practice. Julian, please tell me this isn't about another acquisition gone sideways. Different kind of acquisition. I need a separation protocol memo, compliance and safety focused. Also need you to review some corporate loan documents. How fast can you move? There was a pause. Amara had handled enough divorces in Manhattan's financial district to read between the lines. How fast do you need me to move? Yesterday would have been good. Tomorrow morning is acceptable. I'll have a memo drafted by 6 a.m. Want to tell me what happened? I gave her the 30-second version. Birthday dinner, kids toast, wife's laughter, marriage over. She didn't offer sympathy or ask if I was sure. That's why I paid her $500 an hour. I'll need access to all relevant corporate documents, she said. Loan agreements, security interests, employment contracts. Everything tied to your holding company and her startup. Already pulling them up. After hanging up, I walked to my home office, a room that had started as Maya's yoga studio and gradually evolved into my command center for managing Harbor Ridge Capital's portfolio. 3 monitors displayed real-time market data, corporate dashboards, and the kind of financial information that most people found mind-numbingly boring, but I found deeply reassuring. Numbers don't lie. Numbers don't laugh at birthday dinners. Numbers just exist, waiting to be manipulated by people who understand how they work. I opened the Treasury dashboard for Harbor Ridge Capital LLC, my holding company, the one that held controlling interests in 12 different businesses and enough liquid assets to weather any storm. The interface was clean, modern, the kind of SaaS platform that screamed enterprise-grade security and institutional investors welcome. But tonight, I was interested in one specific line item, a secured company loan I'd made to Verdict AI 2 years ago. Maya's legal tech startup had been her baby since the day she graduated from Columbia Law. The idea was solid. Use artificial intelligence and machine learning to help small and mid-sized law firms draft better litigation briefs, automate document review, and level the playing field against the white-shoe firms with armies of associates. The SaaS platform was elegant, the user interface was intuitive, and the underlying technology was genuinely innovative. In a different world, with different timing and different leadership, Verdict AI could have been a legitimate unicorn. But unicorns need more than good ideas. They need capital, experienced management, and the kind of operational discipline that doesn't come naturally to brilliant lawyers who think venture capital is just free money with better networking events. 2 years ago, when their series of funding hit a snag and their runway was shrinking faster than their subscriber base, Maya had come to me. Not as a husband, as an investor. She'd pitched me in our own living room, using the same slide deck she'd shown to Graham Whitfield and the other VC partners who were suddenly taking longer to return her calls. I'd listened to the whole presentation, asked the right questions about user acquisition costs and lifetime value metrics, and then I'd made her an offer. Not an equity investment, a secured company loan. $2 million, competitive interest rate, with a perfected UCC, one lien on all assets now owned or after acquired. The documentation had been handled by Sloan Park at Park and Keller LLP, the same corporate lawyer who'd been advising Verdict AI since their incorporation. The loan agreement included standard covenants, the kind of terms that any sophisticated lender would demand from a cash-burning startup. No material misrepresentation to stakeholders. No actions causing significant reputational harm to the company or its lenders. Timely payment of all scheduled obligations. Basic stuff, really. The kind of terms that only become problematic if you're planning to do something stupid. Maya had signed without reading the fine print. She'd been focused on the headline number, $2 million to keep her dream alive for another 18 months. She'd treated it like a gift from her supportive husband rather than a commercial transaction with a sophisticated lender who'd structured the deal to maintain maximum control. Tonight, scrolling through the loan documents on my laptop, I felt something I hadn't felt in months. Clarity. The auto-pay function had been dutifully transferring the monthly payments from Verdict AI's operating account to Harbor Ridge's treasury. Clean, automatic, no human intervention required. But autopay was just a convenience feature, not a contractual obligation. I disabled it with 2 clicks. Then I pulled up the covenant compliance reports that Priya Desai, Verdict AI's CFO, had been filing quarterly. Good kid, Priya. Stanford MBA, 3 years at Goldman Sachs before joining the startup world. She understood numbers the way Maya understood legal strategy, which made her the only person at Verdict AI who'd actually read the loan documentation before it was signed. According to her most recent filing, Verdict AI was current on all obligations, maintaining adequate insurance coverage and operating within the parameters established in their corporate charter. But the covenants weren't just about financial metrics. They were about conduct, reputation, and the kind of leadership that institutional lenders expect from their borrowers. I opened a new document and started typing. Notice of event of default. 2. Verdict AI Incorporated. From Harbor Ridge Capital LLC, as senior secured lender. Dear Board of Directors, this letter constitutes formal notice that an event of default has occurred under Section 8.2c of the credit agreement dated date, specifically relating to actions causing material reputational harm to the borrower and its stakeholders. The language was precise, neutral, and completely devastating. I wasn't claiming that Maya had missed a payment or violated any financial covenants. I was declaring default based on conduct, specifically the kind of conduct that makes institutional lenders nervous about the quality of management and the long-term viability of their investments. The beauty of commercial lending is that it's not personal. It's contractual. When a borrower breaches their covenants, the lender has remedies. Those remedies don't depend on whether the borrower intended to cause harm, or whether they think their actions were justified, or whether they were just having a laugh at a birthday dinner. The remedies exist because sophisticated parties agreed to them in advance, when everyone was thinking clearly and acting in good faith. I hit send at 11:47 p.m., copying Priya, Sloan Park, and the other board members. The email would hit their inboxes like a neutron bomb, devastating but precise, destroying the management structure while leaving the underlying business intact. Then I poured another Macallan and stood on the terrace, looking out at the city that never sleeps. Somewhere below, in whatever hotel or friend's couch Maya had landed on tonight, she was probably crafting her narrative about what had happened at dinner. How Julian couldn't take a joke. How successful men are so fragile. How she was the real entrepreneur in the family anyway. What she didn't understand, what none of them understood, was that this had never been about ego or hurt feelings or marital drama. This was about fiduciary duty, contractual obligations, and the fundamental principle that actions have consequences, especially when those actions are taken by people who are supposed to be acting in a position of trust. The city hummed below me, 8 million people going about their lives, most of them blissfully unaware that the difference between success and failure often comes down to reading the fine print and understanding what you're actually agreeing to when you sign your name on the dotted line. I finished my drink, closed my laptop, and went to bed. Tomorrow was going to be a busy day, but tonight, for the first time in months, I was going to sleep soundly. Not because I was happy. Happiness was a luxury I couldn't afford right now. But because I was in control, and control, unlike marriage, was something I actually understood how to manage. The last thing I did before turning off the lights was set my alarm for 6:30 a.m. Santos would have the locks changed by 8, but I wanted to be dressed and ready when Maya realized that equity isn't the same as control, and shareholder definitely isn't the same as spouse. My alarm went off at 6:30 a.m., but I'd been awake since 5:47, staring at the ceiling and running through the day's timeline like a project manager prepping for a hostile acquisition. The thing about corporate warfare is that it's not actually about emotion. It's about execution, precision, and making sure every moving part clicks into place exactly when it's supposed to. Miss your timing by even 15 minutes, and suddenly you're playing defense instead of offense. I made my espresso using the Marzocco machine that Maya had insisted we needed because real entrepreneurs appreciate good coffee. The irony wasn't lost on me as I dialed up a double shot and checked my phone for overnight responses to the default notice. Priya had replied at 1:23 a.m. with a single word, "Understood." Sloan Park's out of office was on, probably catching a red-eye back from some client conference in Silicon Valley. Maya hadn't responded at all, which meant she either hadn't checked her email or was busy consulting with her law school friends about how to spin this into another story about unreasonable men with fragile egos. At 7:15, I called the Harbor Ridge servicer, a guy named Marcus Chun who ran our asset recovery operations with the efficiency of a Swiss watch and the discretion of a confession booth. Marcus had built his reputation at Goldman Sachs before joining our team, and he understood that when I said execute, I meant execute completely, cleanly, and with full documentation for the compliance file. Morning, Julian. Got your notice last night. Teams are already in position. Timeline. Fleet repo crews are staged outside Verdict TAI's office building. Server recovery team is coordinating with the data center. Access control is ready to flip. Just waiting for your final authorization. Marcus wasn't asking if I was sure. He wasn't offering alternatives or suggesting we try mediation first. He was treating this like any other commercial enforcement action because that's exactly what it was. When a borrower defaults on their covenants, the lender has remedies. Those remedies don't become invalid just because the borrower happens to be sleeping with someone who used to sleep with the lender. I checked the time, 7:41 a.m. In 17 minutes, Maya would discover that being CEO of a venture-backed startup doesn't mean much when your company's assets are owned by the senior secured lender. At exactly 7:42, I opened my laptop, pulled up the acceleration letter that Amara had drafted and sent over an hour earlier, and applied my digital signature. The document was beautiful in its simplicity, 2 pages of clean, precise legal language that basically said, "You breached your covenants. We're calling the entire loan due immediately, and we're taking possession of the collateral pending payment in full." The repossession work order was even more elegant. A single page authorizing Harbor Ridge's servicer to secure and recover all assets subject to the perfected security interest, including but not limited to vehicles, equipment, intellectual property, customer lists, software code, and any other property now owned or after acquired by the debtor. I signed both documents at 7:42 a.m. precisely, then forwarded them to Marcus with a single word, execute. At 7:59, my phone buzzed with a text from Marcus. Teams in motion. ETA 8:09. I poured a second espresso, changed out of my workout clothes into a navy cashmere sweater and dark jeans. The kind of casual but expensive look that said, "I'm not going to the office today, but I'm still the guy who signs your paychecks." Then I settled into my home office to watch the show. Harbor Ridge's asset recovery operation was a thing of beauty. We'd spent 3 years building out the infrastructure after acquiring a distressed logistics company and realizing that half of business success is just showing up with the right paperwork at exactly the right time. Our teams were staffed with former military logistics specialists, retired cops who understood the legal boundaries of commercial repossession, and enough attorneys to make sure every I was dotted and every T was crossed. At precisely 8:09 a.m., my dashboard updated with the first green check. Fleet repo. 2 Tesla Model X. Verdict AI. Completed. Maya's matching Tesla Model X SUVs. The ones she'd leased through the company because executive transportation is a legitimate business expense, were now sitting in Harbor Ridge's secure facility in Long Island City. The repo team had found them in Verdict AI's executive parking garage, used the master keys that came with our security documentation, and driven them away while Maya was probably still figuring out how to order an Uber. 8:12 a.m. Server racks under master equipment lease. Collected. Verdict AI's entire technical infrastructure, the AI servers that powered their machine learning algorithms, the customer databases, the proprietary software that took 3 years to develop, was now disconnected and heading to our secure data facility in New Jersey. The recovery team had coordinated with the data center's management, presented our equipment lease agreements, and physically removed every piece of hardware that Verdict AI needed to operate. 8:15 a.m. Office access badges, disabled. This one was almost too easy. The security system for Verdict AI's Soho Loft office was managed by a smart building platform that integrated with their HR software. When you control the master service agreement for the building's technology infrastructure, disabling access badges becomes a simple API call. 8:18 a.m. Corporate Amex, suspended. American Express doesn't mess around when the primary account holder, which happened to be Harbor Ridge Capital, acting as guarantor for Verdict AI's corporate credit line, requests an immediate suspension due to covenant breach by authorized user. Maya's coffee run this morning was going to require cash. 8:21 a.m. Payroll escrow, held pending board authorization. This was the nuclear option, and I'd saved it for last. Verdict AI's payroll was processed through a service that we'd recommended during their Series A bridge funding, mainly because it integrated seamlessly with our treasury management platform. When the senior secured lender flags an account for compliance review pending default resolution, the service provider has no choice but to freeze all outgoing payments until the dispute is resolved. 23 employees, from junior developers to senior product managers, were about to discover that their direct deposits weren't going to hit their checking accounts this Friday, that their health insurance premiums weren't going to be paid, that the company they'd been building for the past 2 years had just become a very expensive collection of intellectual property owned by someone else. The beauty of it was that none of this was personal. It was just business, the kind of business that happens when sophisticated parties sign sophisticated agreements, and then one party decides that covenants are more like suggestions than actual legal obligations. I finished my espresso and pulled up the custody calendar I'd been maintaining since Theo was born. A detailed spreadsheet tracking his school schedule, playdates, doctor appointments, and the kind of information that family court judges love to see from fathers who want to be taken seriously. Maya had always thought I was obsessive about documentation. Today, she was going to learn why obsessive people tend to win complicated disputes. The calendar showed that Theo had soccer practice at 4 p.m. and a sleepover at his friend Jake's house tomorrow night. His pediatrician appointment was scheduled for next Tuesday. His parent-teacher conference was the following Thursday. All the ordinary details of raising a 7-year-old, carefully tracked and managed by the useless father who apparently couldn't handle a simple joke at a birthday dinner. My phone started buzzing with calls. Maya's number, then Priya's, then numbers I didn't recognize, probably Verdict AI, employees who were arriving at the office to find their key cards didn't work and their company cars were missing. I let them all go to voicemail. There would be plenty of time for conversation later, preferably with attorneys present and everything properly recorded for the compliance file. The only emotion I felt was calm. Not satisfaction, not revenge, not the kind of petty triumph that comes from watching your enemies suffer. Just the quiet calm that comes from executing a plan correctly, from understanding the rules of the game better than the other players, from being the kind of person who reads the fine print and actually remembers what it says. Somewhere across town, Maya was probably just figuring out that the Tesla wouldn't start, that her office key card wasn't working, that her corporate credit card had been declined at Starbucks. She was probably calling Priya, who was probably calling Sloan Park, who was probably calling emergency meetings with venture capital partners who were starting to realize that due diligence should have included a more careful review of the company's debt structure. But that was their problem to solve. My problem had been much simpler. How do you respond when someone publicly humiliates you at your own birthday dinner? The answer, it turns out, is that you don't respond at all. You execute. Cleanly, legally, and with enough documentation to satisfy any judge who might eventually review your actions. Maya was about to learn the difference between equity and control, between being a shareholder and being a spouse, between running a company and actually owning the assets that make the company possible. It was going to be an expensive education, but some lessons are worth the tuition. By 9:30 a.m., my phone had been buzzing like a casino slot machine for exactly 91 minutes. 18 missed calls from Maya, 12 from Priya Desai, 6 from numbers I didn't recognize. Probably Verdict AI employees standing outside their locked office building, wondering why their startup badges had suddenly become decorative plastic rectangles. I'd let every single call go to voicemail, not out of spite, but because the next conversation needed to happen with witnesses, proper documentation, and everyone understanding exactly what kind of meeting this was going to be. When Priya finally sent a calendar invite for an emergency board meeting, urgent, I almost smiled. Almost. The kid was learning fast that being CFO of a venture-backed startup means you're the one who has to explain to the board why the company's assets just vanished into thin air. The meeting was scheduled through Verdict AI's usual Zoom Pro account, the one paid for with their corporate Amex, the same Amex that was currently suspended pending resolution of their covenant breach. The irony was so thick you could serve it at a $48,000 birthday dinner. I joined the call from my home study at exactly 9:30, camera on, positioned so the gray morning light from the floor-to-ceiling windows gave me that Warren Buffett meets Michael Clayton look that intimidates the shit out of people even when you're wearing a navy cashmere sweater instead of a $1,000 suit. The background showed my law degree from NYU, my Series 7 and 66 certifications, and just enough of my book collection to suggest I actually read the documents I sign. The other participants were already in their little Zoom squares, looking like they'd been dragged out of bed to attend their own execution. Priya appeared to be calling from her kitchen, still in a Columbia Business School hoodie, her usually perfect hair pulled back in what my ex-wife would have called a crisis ponytail. Her voice was shaking when she opened the meeting, and I could see her hands trembling as she shared her screen with the board agenda. Good morning, everyone. Thank you for joining on such short notice. We have a situation. Graham Whitfield from Whitfield Capital looked like he was dialing in from his private jet, again. The man seemed to live at 30,000 feet, probably because it was harder for process servers to find you in international airspace. His background showed the kind of generic luxury that screams, I leased this plane by the hour and expense it to my fund. He was wearing a polo shirt that probably cost more than most people's rent, but somehow managed to look like he'd slept in it. The Honorable Mira Carver, Verdict AI's independent director, was clearly in her home office in what looked like the Upper East Side. Book-lined walls, art that suggested old money, and the kind of composure that comes from 30 years on the federal bench before retiring to collect director fees from startups that need credible adult supervision. She'd probably seen enough corporate drama to write a textbook on fiduciary duty breaches. Sloan Park from Park and Keller LLP was the only one who looked professionally ready for this conversation, dialing in from what was obviously her law firm's conference room, wearing a crisp white shirt and the kind of neutral expression that corporate attorneys practice in the mirror. She had a stack of documents in front of her and 2 associates just off camera, probably frantically researching precedents for what happens when the founder's husband forecloses on the company. And then there was Maya, appearing on screen for the first time since last night's birthday dinner disaster. She'd found somewhere to stay. Looked like a hotel room, probably the W or the Edition, somewhere expensive enough to maintain the illusion that this was all just a temporary inconvenience. Her makeup was flawless, her hair was perfect, and she was wearing the kind of power blazer that cost more than most people's cars. But her eyes had that slightly manic gleam that comes from running on pure adrenaline and whatever stimulants keep venture-backed CEOs functional during crisis situations. Our assets were seized by the senior secured lender, Priya began, her voice barely steady. As of 8:09 this morning, we no longer have access to our office, our vehicles, our servers, or our corporate credit lines. Payroll has been frozen pending board authorization that we can't provide because we can't access our own systems. The silence that followed was the kind of awkward pause that happens when everyone knows exactly what's going on, but nobody wants to be the first person to say it out loud. Graham was probably calculating how much of his fund's investment was about to become a tax write-off. Judge Carver was likely running through the fiduciary duty implications of a board that had somehow missed the fact that their largest creditor was married to their CEO. Sloan was definitely billing this call at her highest hourly rate while trying to figure out how to advise a client whose entire business model had just been repossessed by their founder's ex-husband. The lender is. Priya swallowed hard, looking directly at my camera. Julian's holding company. Harbor Ridge Capital LLC. Graham tried to salvage some authority from the situation, leaning forward with the kind of aggressive posture that probably worked great in conference rooms but looked ridiculous over video chat. This is clearly a hostile takeover disguised as debt enforcement. We need to consider all available remedies, including emergency injunctive relief. I let him finish his little speech before responding, keeping my voice level and professional. Graham, hostile takeover is an equity strategy. You buy shares, you proxy votes, you replace management through shareholder democracy. This is debt enforcement under a documented event of default. I suggest you read the covenants. The beauty of being right is that you don't have to raise your voice or get dramatic. You just state facts and let other people figure out how fucked they actually are. Priya, bless her heart, tried to provide some context. Julian's holding company has been funding our payroll for the past 6 months when our Series B funding round experienced delays. The loan documentation includes standard covenant protections for the lender. Judge Carver spoke up for the first time, her voice carrying the kind of authority that comes from decades of sorting out complicated legal disputes. Mr. Harper, what are your intentions regarding the company's operations and its employees? This was the question I'd been waiting for, the moment when everyone would understand that this wasn't about revenge or hurt feelings or marital drama. This was about leadership, accountability, and the basic principle that companies need to be run by people who understand the difference between fiduciary duty and personal amusement. I protected the employees when the Series B funding fell through, I said, looking directly into the camera. I advanced payroll when their salaries were at risk. I provided bridge financing when their runway was disappearing. I will continue to protect them, under appropriate governance structures and with proper oversight. Maya finally spoke, and I could hear 8 years of marriage in her voice, the familiar mix of entitlement and disbelief that came out whenever she encountered consequences she hadn't anticipated. You wouldn't do this, Julian. Not to the company. Not to me. I looked straight into the lens, the same way I looked at hostile witnesses during depositions, and delivered the line I'd been rehearsing since I walked out of that birthday dinner. Yesterday, this board sat in a room that cost $48,000 for one evening and laughed while a 7-year-old repeated his mother's description of his father as useless. This is not about personal feelings. This is about leadership, governance, and basic standards of professional conduct. The silence that followed was different from the earlier awkwardness. This was the silence of people realizing that they'd fundamentally misunderstood what kind of game they were playing and who they were playing it with. Judge Carver was the first to break it. I believe this meeting should be adjourned pending proper legal consultation for all parties. I nodded once. Agreed. Sloan, please ensure all board members receive copies of the relevant loan documentation, including the covenant requirements and default provisions. Marcus Chun from Harbor Ridge will be coordinating operational continuity for the company's clients and employees. The meeting ended at 9:38 a.m. 8 minutes of conversation that had just rewritten the entire corporate structure of a company that 3 days ago was worth $12 million on paper. A lawyer would call it efficient. I called it overdue. After everyone signed off, I sat in my study for exactly 60 seconds, watching the gray morning light shift across Manhattan's skyline. Somewhere across town, Maya was probably already on the phone with divorce attorneys, spinning this into another story about unreasonable men who can't handle successful women. Graham was likely explaining to his limited partners why their investment in revolutionary legal technology had just become a case study in the importance of reading loan documentation. But that was their problem now. My problem was simpler. How do you rebuild a company when the previous management team confused venture capital with monopoly money and thought covenant compliance was optional? The answer, it turned out, was the same way you handle any other corporate restructuring. One board meeting at a time. The thing about nuclear options in corporate warfare is that once you deploy them, everyone suddenly remembers they're supposed to be adults. By 10:15 a.m., my phone had stopped buzzing with angry calls from Maya and started pinging with formal communications from attorneys who understood that this situation had moved way beyond marriage counseling into the realm of serious legal consequences. Amara called me at 10:30, her voice carrying that particular brand of controlled excitement that comes from billing $700 an hour to clean up other people's messes. I've got 3 different law firms trying to reach me about emergency injunctions, temporary restraining orders, and something called unconscionable debt enforcement practices. Want to tell me how you'd like to handle this? Professionally and by the book, I said, settling into my home office with a fresh espresso. Maya needs space to figure out her next moves without feeling cornered. Theo needs stability while his parents sort out their shit like adults. And Verdict AI's employees need to know their jobs are secure while we restructure the company properly. Got it. I'm drafting a comprehensive response package. Family court filing first, then corporate standstill agreements, then a formal restructuring proposal for the board. This is why I paid Amara enough money to afford her own Upper West Side co-op and send her kids to private school. She understood that the best legal strategy isn't about winning every battle. It's about controlling the battlefield and making sure everyone understands the rules of engagement. The first document she drafted was a petition for a temporary protective order under New York domestic relations law. Not the kind of restraining order that makes headlines and ruins careers, but the kind of legal breathing room that prevents ugly situations from getting uglier. The filing was clean, neutral, and focused on child custody arrangements rather than marital fault or financial disputes. Petitioner seeks temporary court-supervised custody arrangements to ensure continuity of care for the minor child, while parties address separation-related issues through appropriate legal channels. Amara had written, in the kind of language that family court judges appreciate for its lack of drama and excess of actual legal substance. The protective order wasn't about punishment. It was about creating predictable boundaries while Theo's entire world was being reshuffled. Shared custody with clear schedules, communication protocols that went through attorneys instead of midnight text message fights, and the kind of structure that meant a 7-year-old wouldn't have to worry about whether daddy was going to be at soccer practice or mommy was going to remember to pack his lunch. The formal separation notice was even more straightforward. 2 pages of legal language that basically said, "This marriage is over. Let's divide assets according to the law instead of through social media posts and mutual friends taking sides." New York's equitable distribution statutes are pretty clear when you've got proper documentation, and I'd spent 7 years making sure every significant asset was properly documented. On the corporate side, Amara was drafting what she called a standstill agreement, basically a promise that Harbor Ridge wasn't going to fire everyone and liquidate Verdict AI's assets while the lawyers figured out how to restructure the company properly. The document was designed to calm down employees who were probably updating their LinkedIn profiles and wondering if their health insurance was still valid. All current Verdict AI personnel may retain company-issued laptops and equipment for remote work purposes. Payroll and benefits continuation guaranteed through Harbor Ridge Capital for a minimum of 90 days. Reporting structure transitions to interim operational management pending board-approved restructuring. I also had Marcus send formal notice to Graham Whitfield and the other VC investors about a potential Article 9 sale, the kind of legal proceeding that happens when a secured creditor decides to sell a debtor's assets to recover their investment. The notice was required under the Uniform Commercial Code, and it basically gave them 30 days to either cure the default by paying off the entire loan balance or accept that Harbor Ridge was going to become Verdict AI's new owner through a perfectly legal foreclosure process. The restructuring proposal I sent to Priya was probably the document I was most proud of. One page, plain English, no legal jargon or corporate buzzwords. Just a simple explanation of how we were going to save everyone's jobs while fixing the fundamental problems that had led to this situation in the first place. Verdict AI Restructuring Plan. 90-day timeline. The header read, followed by bullet points that any Stanford MBA could understand without a translation from corporate counsel. Harbor Ridge acquires operational control through debt-to-equity conversion. Current employees retain positions with same compensation and benefits. Customer contracts and service agreements remain in full effect. New management structure focused on sustainable growth rather than venture capital theatrics. Clear path to profitability within 18 months based on existing customer base. No layoffs, office relocations, or service disruptions during transition period. When Priya called me after reading the proposal, I could hear her crying on the other end of the line, not from fear or anger, but from pure relief. Julian, I've been losing sleep for months trying to figure out how to make payroll without begging Graham for another bridge round. This actually gives us a chance to build something sustainable. That's the point, Priya. Verdict AI is a good company with solid technology and loyal customers. It just needs leadership that understands the difference between running a business and performing for venture capital investors. She was quiet for a moment, probably processing the implications of what I'd just said about her former CEO. Maya's brilliant, you know. The AI technology she designed is genuinely innovative. But running a company requires different skills than practicing law or impressing investors. I finished for her. Skills that can be learned, but not while you're treating other people's money like monopoly cash and covenants like suggestions. That afternoon, I sent a formal notice to all Verdict AI employees through Marcus, explaining that their jobs were secure, their benefits would continue uninterrupted, and the company was entering a restructuring phase designed to ensure long-term stability. The tone was professional, reassuring, and completely devoid of any reference to the personal drama that had triggered this entire situation. I also sent a personal note to each member of Verdict AI's product team, acknowledging their work on the AI platform and emphasizing that the technical direction of the company wasn't changing, just the financial structure and operational oversight. By 4 p.m., Amara had filed all the paperwork, Marcus had delivered the employee notices, and I'd received confirmation that the temporary protective order hearing was scheduled for the following Tuesday. Maya would be represented by Jennifer Kozlov from Kozlov & Associates, a firm that specialized in high-net-worth divorces and probably charged enough per hour to fund a small startup. I poured another Macallan and stood on the terrace, watching the late afternoon sun reflect off the Hudson River. The city hummed below me with its usual energy. Millions of people going about their lives, building businesses, raising families, making the kind of everyday decisions that don't require board meetings or legal documentation. Somewhere in Manhattan, Maya was probably in a conference room with Jennifer Kozlov, learning about asset protection strategies and wondering how a simple birthday dinner had turned into a comprehensive legal and corporate restructuring. Graham Whitfield was likely on a plane to somewhere, calculating whether his fund's investment in Verdict AI was recoverable or just another tax write-off in a portfolio designed to absorb exactly these kinds of failures. But those were their problems to solve. My problem was simpler. How do you co-parent with someone who publicly humiliated you while running their company into the ground? The answer, it turned out, was the same way you handle any other complicated relationship between parties with competing interests. You establish clear boundaries, document everything, and let attorneys handle the communication until everyone remembers how to behave like adults. The process server found Maya at 6:47 p.m., according to the delivery confirmation I received on my phone. She was apparently having drinks at some rooftop bar in Soho, probably with her law school friends, spinning this whole situation into another story about impossible men and their fragile egos. The envelope contained copies of all the legal filings, the corporate restructuring proposal, and a cover letter that Amara had written in the kind of neutral, professional language that makes it clear the time for emotional appeals and birthday dinner drama is officially over. Let's be adults and be clear, the letter concluded. Simple, direct, and completely devastating in its implications. By tomorrow morning, Everyone involved would understand that this situation had moved beyond hurt feelings and marital disputes into the realm of serious legal and financial consequences. And for the first time in months, I was looking forward to getting back to work. Maya decided to make her grand entrance at exactly noon on Saturday, which told me everything I needed to know about her strategic thinking. Saturday meant the building's management office was closed, so there'd be no witnesses with actual authority if she decided to create a scene. Noon meant she'd had time to lawyer up, caffeinate, and probably rehearse whatever performance she'd planned with her Columbia Law School support group. The fact that she brought an audience told me she still didn't understand the fundamental difference between being right and being loud. My doorman, Carlos, called up from the lobby with the kind of carefully neutral tone that comes from 20 years of managing Manhattan real estate drama. "Mr. Harper, your wife is here with two companions. They're requesting access to the penthouse. She mentioned something about illegal lockouts and says she's recording for legal purposes." Through the lobby's security camera feed on my phone, I could see Maya flanked by two women I recognized from various law school networking events, the kind of attorneys who specialized in high-conflict divorces and probably charged their clients extra for dramatic flair. One of them was holding an iPhone in that obvious way that screams, "We're documenting everything for our inevitable lawsuit," while Maya herself was wearing what I'd learned to call her court outfit, a sharp black blazer that cost more than most people's rent, designed to project authority while suggesting she was the victim of unreasonable circumstances. "Tell her counsel is available to discuss any concerns," I said, pulling on a pair of jeans and a Columbia MBA sweatshirt. If Maya wanted to play the reasonable professional card, I could play it better. I took the elevator down to the lobby, not because I was required to, but because avoiding Maya would look like exactly the kind of guilty behavior her attorneys were hoping to document. When the doors opened, I found myself facing three women who looked like they'd spent the morning preparing for a deposition rather than a conversation. Amara was already there, of course, because paying your attorney $700 an hour means she shows up when you need her, even on Saturday afternoons. She was wearing jeans and a cashmere sweater, the kind of casual but expensive look that communicated, "I'm here as a favor, but I'm still the smartest person in this room." Her presence immediately shifted the dynamic from angry wife confronts husband to opposing counsel discusses client concerns. "Maya," I said, keeping my voice neutral and professional, "I understand you have some questions about the residential arrangements." The friend with the iPhone moved closer, obviously hoping to capture some kind of dramatic confrontation that would play well in family court. Maya launched into what was clearly a rehearsed speech about illegal lockouts and marital property and unconscionable behavior, using the kind of legal language that sounded impressive but demonstrated a fundamental misunderstanding of how property law actually works. Amara let her finish, then asked the question that immediately deflated the entire performance. "Maya, would you mind reading the residential lease rider aloud? The document you signed when Julian bought this apartment." The iPhone stopped recording. The two law school friends suddenly found the lobby's marble floors extremely interesting. Maya's perfectly prepared speech evaporated as she realized that her audience was about to hear her own signature on legal documents that explicitly established the penthouse as Julian's separate property, held in a premarital trust, with exclusive possession clauses that had been drafted specifically for situations exactly like this. The apartment was purchased by Julian Harper prior to marriage, held in irrevocable trust, with Maya Sterling Harper granted limited residential privileges during the term of marriage, Amara read from her phone, where she'd obviously pulled up the relevant documentation. Termination of marriage automatically revokes residential privileges, with 30-day notice period waived in cases of marital misconduct or breach of residential agreements. The beautiful thing about proper legal documentation is that it eliminates drama. You can't argue with your own signature, and you can't claim ignorance of terms you agreed to when a qualified attorney explained them to you 3 years ago during the apartment refinancing. Maya pivoted to her fallback strategy, money and emotional manipulation. "Your entire portfolio exists because I stayed home with Theo while you chased deals and built your precious holding company. I sacrificed my career to support your ambitions." This was the moment I'd been preparing for since walking out of that birthday dinner. Not the legal arguments or the corporate restructuring or the custody arrangements. But this specific accusation that my success was somehow built on her sacrifice, that Harbor Ridge Capital was a joint venture rather than something I'd built through 15 years of 18-hour days and weekend deal negotiations. Maya, I said, looking directly at the iPhone that was now recording again, I'm not going to argue about the past, but I am going to be clear about the future. I pulled out my own phone and opened the voice recording app, because if we were documenting this conversation, everyone should have their own copy. I will not engage in public drama about our marriage. I will not make statements to mutual friends or professional contacts about your conduct. I will not use social media to score points or build sympathy. The divorce will be handled through proper legal channels with qualified representation for both parties. The two friends exchanged glances. This wasn't the angry, defensive reaction they'd been hoping to provoke and record. This was a man establishing boundaries and refusing to participate in the kind of emotional theater that makes for compelling social media, but terrible legal strategy. Theo's custody arrangements will be determined by family court based on his best interests, not by whoever can generate the most sympathy or outrage. His schedule, his school, his healthcare, his emotional stability. All of that gets decided by professionals whose job is protecting children, not by parents trying to punish each other. Maya tried to interrupt, but I wasn't finished. Verdict AI's restructuring will proceed according to the loan agreements and corporate governance documents that everyone signed when they thought venture capital was free money. The employees will keep their jobs, the customers will keep their service, and the company will be run by people who understand the difference between fiduciary duty and performance art. I ended the recording and put my phone away. Now, if you have specific legal concerns about the property arrangements or custody schedule, please have your attorney contact Amara to discuss them properly. If you're here to perform for social media, you're wasting everyone's time. The lobby fell quiet except for the soft hum of the building's HVAC system. Maya's two friends were clearly reevaluating whether this was the kind of drama they wanted to be associated with. Their client, the brilliant legal tech entrepreneur who was being victimized by her unreasonable husband, had just been offered exactly the kind of professional, by-the-book resolution that makes for boring Instagram posts but solid legal outcomes. That evening, I was scrolling through LinkedIn when Graham Whitfield's latest post appeared in my feed. A photo of him boarding a private jet at Teterboro, champagne glass in hand, with a caption about vision and velocity in challenging markets. The comments were full of other venture capital partners offering solidarity and talking about disruptive innovation and staying focused on the future. I stared at the post for exactly 1 second, then closed the app and walked to the bathroom mirror in my master suite. The face looking back at me was the same one that had built Harbor Ridge Capital from nothing, the same one that had structured deals worth hundreds of millions of dollars, the same one that had been called useless at a $48,000 birthday dinner. Graham needed a private jet and social media validation to feel important. Maya needed an audience and performance theater to feel powerful. But I didn't need either of those things because I had something more valuable. A mirror that reflected exactly who I was, what I'd built, and what I was capable of doing when people confused my restraint for weakness. The man in the mirror had just systematically dismantled his wife's company, restructured a failing startup into a profitable business, and established custody arrangements that would protect his son from the fallout of his parents' divorce. All without raising his voice, making dramatic gestures, or needing an audience to validate his decisions. I didn't need a jet to feel powerful. I had a mirror, a plan, and the kind of quiet confidence that comes from understanding exactly what you're capable of when someone mistakes your civility for vulnerability. Tomorrow, I get back to the business of rebuilding Verdict AI properly. Tonight, I'd sleep soundly in my own bed, in my own apartment, in a city that was finally starting to make sense again. By Monday morning, the financial press had caught wind of the story, not the personal drama. That was nobody's business but ours, but the corporate angle that had all the venture capital firms in Manhattan suddenly revisiting their own portfolio companies' debt structures. Legal tech startup Verdict AI faces asset seizure by senior secured lender was the headline in TechCrunch, written in that breathless style that made it sound like some kind of Silicon Valley thriller instead of a routine commercial foreclosure. I called an all-hands board meeting for 2 p.m., not because I needed their permission for what came next, but because good corporate governance means keeping everyone informed when you're about to fundamentally restructure their investment. The solution I developed over the weekend was elegant in its simplicity. Harbor Ridge would acquire Verdict AI through what corporate lawyers call a friendly foreclosure sale. Basically, we buy the company's assets at fair market value, assume the key liabilities that mattered, and convert our outstanding debt into controlling equity. The beauty of the structure was that everyone got something they actually needed instead of something that made them feel good. The employees kept their jobs, their health insurance, and their equity upside if we hit the performance benchmarks I'd built into the new compensation structure. The customers kept their service without interruption, their data stayed secure, and their contracts remained in full effect. Even Graham's fund got a path to recover their investment through earn-out provisions tied to revenue growth and profitability milestones. The only hard piece, as I explained to the board, was that Maya would be stepping aside as CEO. Not because I was vindictive, but because rebuilding Verdict AI required the kind of operational discipline and financial acumen that comes from actually running profitable businesses instead of performing for venture capital audiences. "This is theft," Maya said when I finished presenting the restructuring proposal, her voice carrying that particular brand of outrage reserved for people who've never encountered real consequences for poor decision-making. Sloan Park, Verdict AI's corporate counsel, had obviously spent the weekend reviewing the loan documentation and UCC filings. "Actually, Maya, this is a standard commercial remedy under Article 9 of the Uniform Commercial Code. Harbor Ridge has a perfected security interest in all company assets, and the covenant breaches provide clear grounds for acceleration." Graham tried one last desperate play, leaning into his camera with the kind of aggressive posture that probably worked great in conference rooms, but looked ridiculous over Zoom. "This is completely off-market. No rational investor would structure a deal this way." "Graham," I replied, keeping my voice level and professional, "rational investors read the loan documentation before they advise their portfolio companies to sign it. This structure protects everyone's interests while ensuring the business can actually survive long enough to generate returns." Judge Carver, bless her, cut straight to the heart of the matter. "What are the alternatives if the board rejects this proposal?" I pulled up the liquidation analysis that Marcus had prepared over the weekend. Article 9 sale of all assets, probably generating 60 to 70 cents on the dollar for secured creditors. Employees lose their jobs, customers lose their service, and the VC investment becomes a total write-off. The silence that followed was the sound of people doing basic math and realizing they didn't have better options. Priya called me 30 minutes after the meeting ended, and I could hear something I hadn't heard in her voice for months: hope. "Julian, this is Mercy. You could have liquidated everything and walked away with your investment. Instead, you're giving us a chance to actually build something sustainable." "Don't say that to me, Priya. Say it to your team. They're the ones who did the work while management was playing venture capital theater." That afternoon, our compliance audit turned up exactly what I'd expected to find: personal charges on the corporate American Express account that had nothing to do with legitimate business expenses. A luxury spa weekend in the Hamptons. A $12,000 Hermes bag from the Madison Avenue boutique. Dinner at 11 Madison Park for 8 people who weren't clients, customers, or employees. I didn't wave it around or leak it to the business press. I just put the documentation in a folder labeled "Don't use unless necessary" and filed it in my safe. Some ammunition is more effective when people know you have it, but hope you'll never need to use it. The difference between winning and winning ugly is knowing when to be generous with people who've learned their lesson and when to be ruthless with people who still think the rules don't apply to them. Maya would figure out which category she belonged to soon enough. By close of business Monday, Verdict AI had a new ownership structure, a sustainable business plan, and a management team that understood the difference between building value and building buzz. The employees kept their jobs, the customers kept their service, and Graham's fund got a second chance to see returns on their investment. Maya kept her equity stake, diluted, but still meaningful if we hit our targets. What she didn't keep was the illusion that being CEO meant you could treat other people's money like play money and covenants like suggestions. Sometimes the best deals are the ones where everyone gets exactly what they need, even if it's not what they wanted. The thing about corporate turnarounds is that they're less about grand gestures and more about showing up at 6 a.m. with a decent espresso and a checklist of things that need to work before lunch. When I arrived at Verdict AI's Soho Loft office Tuesday morning, Marcus was already coordinating with the ops crew, a mix of IT specialists and business continuity experts who'd helped us resurrect 3 different distressed acquisitions over the past 2 years. The server room looked like the aftermath of a very precise hurricane. Our asset recovery team had been thorough when they'd pulled the equipment, but they'd also been professional. Every cable labeled, every component cataloged, every database backed up to our secure facility in New Jersey. Bringing it all back online wasn't rocket science, just expensive patience and the kind of systematic approach that venture-backed startups never budget for. By 7:30, we had the AI servers humming again, customer databases restored from encrypted backups, and the machine learning algorithms that powered Verdict AI's brief writing platform running their usual diagnostic cycles. The software hadn't suffered during its temporary exile. Code doesn't care about corporate drama, just proper version control and adequate server resources. At exactly 8 a.m., I stood in front of Verdict AI's entire staff, 23 people who'd spent the past 4 days wondering if they still had careers, and delivered the speech I'd been rehearsing since Sunday night. Paychecks continue. Healthcare continues. Your stock options remain valid under the new equity structure. We have 90 days to prove this company can be profitable instead of just promising. No jargon about synergistic realignment or right-sizing for optimal growth trajectory. Just the basic information that adults need to make decisions about their careers and their families. I explained our new product thesis. Build a simple, secure brief builder that small and mid-sized law firms could actually use without needing a PhD in computer science or a CFO to decode the billing structure. AI that worked reliably instead of impressively. Machine learning that could be audited by compliance officers instead of just venture capital partners. SaaS contracts that law firms could actually understand and afford. No fireworks, no disruption, just a working product that helps lawyers practice law more efficiently. I concluded. If you're here to sue me, I understand. If you're here to build something sustainable, I'll be at my desk. By lunch, 3 mid-sized litigation shops had re-signed their service agreements, attracted by our new pricing structure that charged for value delivered instead of seats licensed. We'd eliminated the VC-friendly metrics that looked impressive in board decks, but made no sense to actual customers who needed to bill clients and pass compliance audits. For the first time in months, Verdict AI felt like a real business instead of an expensive performance art project. The air in the office was different, focused, practical, relieved. People were working instead of wondering if their next paycheck would clear. It felt like oxygen after holding your breath for 2 years. Family Court in Manhattan operates on the principle that children deserve better than whatever drama their parents can't figure out how to handle privately. Judge Patricia Morrison had been dealing with high-net-worth custody disputes for 15 years, which meant she'd seen every possible variation of wealthy people using their kids as weapons in financial warfare. The fact that she'd agreed to an expedited hearing told me she understood this case was about protecting a 7-year-old from his parents' inability to behave like adults, not about determining who was more wronged in the dissolution of a marriage. I arrived at 60 Center Street at 8:30 a.m. wearing my most conservative Navy suit, the one that said responsible father instead of private equity predator. Amara was already there, briefcase full of documentation that demonstrated what she called extraordinary preparation for parental responsibilities. Maya's attorney, Jennifer Kozlov, was setting up at the opposing table with enough files to suggest they were planning to relitigate the entire marriage instead of just establishing a custody schedule. Judge Morrison reviewed our submitted parenting plans for exactly 12 minutes before looking up with the expression of someone who'd seen this movie too many times. Mr. Harper, Miss Sterling, I'm not interested in speeches about who's the better parent or whose fault this divorce is. I'm interested in what's best for Theodore Harper, age 7, who shouldn't have to suffer because his parents can't figure out how to communicate without attorneys. The beauty of having kept detailed records for 7 years was that I could answer every question about Theo's life without checking notes or conferring with counsel. His pediatrician was Dr. Sarah Chun at NYU Langone. His school schedule included soccer practice Tuesdays and Thursdays, piano lessons Wednesday afternoons, and a standing playdate with Jake Morrison every other Friday. His bedtime routine involved 2 books, a glass of water, and exactly 14 minutes of just one more question, Daddy, before he finally fell asleep. Maya's attorney tried to paint me as the absent father who prioritized business over family, but the documentation told a different story. School pickup records showing my attendance at 73% of dismissals. Pediatric appointment schedules with my name listed as the primary contact. Youth Soccer League volunteer coaching certification from when Theo decided he wanted to try sports. The kind of mundane parental data that venture capital partners and legal tech entrepreneurs don't usually maintain in spreadsheets, but that family court judges find extremely persuasive when determining custody arrangements. Your Honor, I said when asked to explain my position, I don't want to win custody. I want Theo to have 2 parents who can co-parent effectively without putting him in the middle of their personal issues. Whatever schedule serves his best interests is the right schedule. Judge Morrison awarded us a temporary shared custody arrangement. Alternating weeks, with clear protocols for school events, medical decisions, and holiday schedules. She also mandated something that probably saved all 3 of our lives. A co-parenting class that neither Maya nor I could delegate to our attorneys or skip because of business travel. And both parents will attend individual counseling to address the underlying issues that led to this dissolution, she added, looking directly at me. Mr. Harper, successful people often think therapy is for other people. In my experience, successful co-parenting requires everyone to do the work. My first quiet night with Theo happened the following Tuesday. He'd spent the afternoon at his new school. We'd transferred him to Collegiate, a place where the other kids' parents were dealing with similar family transitions, and the guidance counselors actually understood the psychology of divorce in high-net-worth households. We ordered Chinese takeout and ate it on the floor of the living room while watching some animated movie about talking cars, which seemed appropriately mindless after a day of corporate restructuring and custody arrangements. Halfway through dinner, Theo looked up from his lo mein with the kind of serious expression that meant he'd been thinking about something important. Daddy, am I in trouble? Because of what I said at your birthday. I put down my chopsticks and knelt next to him, the way my own father never did when I was 7 and had complicated questions about complicated situations. No, buddy, you're not in trouble. Words aren't trouble when they're honest. Sometimes grown-ups put heavy words on little shoulders, and that wasn't your job to carry. We spent the next hour coloring a rocket ship, adding stars and planets, and the kind of elaborate background details that 7-year-olds think are essential to any space exploration mission. He asked if rockets are loud when they launch, and I told him yes. They're incredibly loud, but the best part is when they get high enough above Earth that they're finally above all the noise. Like above the arguing? He asked, adding another star to our drawing. Exactly like that. Later that evening, after Theo was asleep, I called Dr. Rachel Stern, the therapist that Amara had recommended when I'd asked for someone who specialized in helping high-functioning adults deal with life transitions that couldn't be solved through strategic planning and better documentation. She had availability the following week, which felt like a minor miracle in Manhattan's competitive therapy market. But the more important call was to Dr. Lisa Martinez, a child psychologist who specialized in helping kids navigate divorce situations where the parents were too wealthy and too stubborn to prioritize their children's emotional well-being over their own need to be right. Her practice was on the Upper East Side, and her waiting room was probably full of kids whose parents owned companies and fought about custody schedules instead of just figuring out how to raise healthy humans. I want to make sure Theo doesn't end up thinking that love is conditional on performance, I explained during our initial consultation. That relationships don't have to be power struggles. That sometimes adults make mistakes, but that doesn't mean the world is unsafe. Dr. Martinez nodded with the kind of professional understanding that comes from dealing with Manhattan's elite dysfunction on a daily basis. Play therapy can help him process the family changes without feeling like he needs to choose sides or fix his parents' problems. Children often blame themselves for adult conflicts, especially when those conflicts get public attention. Booking that appointment felt more significant than any board vote I'd ever won, any deal I'd ever closed, any acquisition I'd ever structured. This wasn't about market dominance or portfolio optimization or proving that I understood corporate law better than my ex-wife's venture capital advisors. This was about making sure that a 7-year-old kid didn't spend the rest of his life thinking that his innocent birthday toast had somehow caused his family to explode. Driving home from Dr. Martinez's office, I realized that the most important restructuring I was managing wasn't Verdict AI or Harbor Ridge Capital or even my marriage. It was figuring out how to be the kind of father who could help his son navigate the complexity of adult relationships without losing his own sense of trust and security. The custody schedule, the co-parenting classes, the therapy appointments. All of it was just infrastructure for the real work of raising a kid who understood that love isn't contingent on perfect behavior, that conflict doesn't mean catastrophe, and that sometimes rockets are loud when they launch, but eventually they get above the noise and find the quiet space where they can actually see clearly. That night, I sat in Theo's room for an extra few minutes after reading him his bedtime stories, watching him sleep with the kind of peaceful expression that comes from knowing your world is stable, even when the adults around you are figuring out how to rebuild their lives. For the first time since that birthday dinner, I felt like I might actually know what I was doing. 6 months later, I was sitting in a conference room at Blackstone's Manhattan headquarters, listening to a private equity managing director explain why Verdict AI represented exactly the kind of boring excellence that institutional investors had been searching for in the legal tech space. The Article 9 sale had closed 3 months earlier, clean and efficient, with Harbor Ridge acquiring Verdict AI's assets for exactly what they were worth instead of what venture capital had convinced everyone they should be worth. We'd cut the bloat. No more Soho loft office that cost more per month than most law firms' annual technology budgets. The new headquarters was in a sensible building in Midtown South, close enough to the courts that our actual customers could visit without feeling like they were touring a tech startup theme park. We'd kept the soul, the AI platform that actually helped lawyers draft better briefs, the machine learning algorithms that could review contracts without hallucinating clauses that didn't exist, the customer service team that understood legal compliance requirements instead of just growth hacking metrics. The version of Verdict AI we'd shipped in March was revolutionary in its ordinariness. It worked exactly as advertised. It charged reasonable prices for measurable value. It passed security audits without requiring customers to hire consultants to interpret the compliance documentation. Law firms could actually afford it, understand it, and trust it with confidential client information. Priya had evolved into the kind of CEO that boards of directors dream about, competent, disciplined, focused on building long-term value instead of optimizing for the next funding round. She understood unit economics, customer acquisition costs, and the difference between revenue growth and actual profitability. More importantly, she understood that running a legal tech company meant serving lawyers, not performing for venture capital partners who'd never built an hour in their lives. Ray Lin, our new CTO, had transformed the technology stack from an impressive demonstration of machine learning capabilities into a robust platform that could handle the mundane reliability requirements of actual law firms. The AI didn't try to be clever. It just worked, consistently, with the kind of predictable performance that allows small firms to compete with white-shoe practices without hiring armies of junior associates. Harbor Ridge Capital has built exactly what the legal services market needed, the Blackstone MD was saying, reviewing our quarterly metrics on his tablet. Sustainable growth, proven customer retention, clear path to profitability. This is how you scale B2B SaaS in regulated industries. The acquisition offer was generous but not stupid. 8 times annual recurring revenue, with earnouts tied to customer growth and profit margins rather than vanity metrics like user engagement or viral coefficients. It was the kind of deal that made sense for everyone involved. Institutional investors got a stable return in a growing market. Employees got liquidity for their equity stakes, and customers got the reassurance that their legal tech provider was backed by serious capital instead of venture capital theater. I'd stay on as executive chair and majority shareholder, but Priya would remain CEO and the everyday face of the company. My job would be strategic oversight and making sure Verdict AI never again confused venture capital with actual business strategy. That evening, instead of celebrating at some $48,000 venue with people who measured success by how much they could spend on dinner, I cooked pasta with Theo standing on a stool beside me, arguing about whether mushrooms belonged in carbonara sauce. He'd grown 3 inches since that birthday dinner, lost 2 teeth, and developed strong opinions about Italian food that he'd inherited from exactly no one in his family. The custody arrangement had settled into something that actually worked: shared weeks, coordinated schedules, and the kind of co-parenting relationship that prioritized Theo's needs over our own need to be right about everything. Maya and I had learned to communicate through a shared calendar app and brief, professional text messages that focused on pickup times and school events instead of relitigating our marriage through passive-aggressive emoji usage. The co-parenting class had been more useful than either of us had expected, mainly because it forced us to practice having boring conversations about practical topics: summer camp applications, orthodontist appointments, college savings plans, without turning everything into a referendum on who was the better parent or whose fault the divorce had been. After dinner, I poured exactly 2 fingers of Macallan, not the 25, just the 18, because some habits need modification, and opened my laptop to join Verdict AI's monthly board meeting. These calls had become refreshingly brief affairs focused on actual business metrics instead of fundraising narratives or competitive positioning against other legal tech startups that were burning through Series B funding to build products that nobody actually wanted to buy. Customer acquisition cost is down 12% this quarter, Priya reported, and customer lifetime value is up 18%. We're ahead of schedule on the path to profitability. No dramatic presentations about disrupting the legal industry or revolutionizing how law firms operated. Just the boring, profitable reality of building software that solved actual problems for people who paid their bills on time. My phone buzzed with an email from Graham Whitfield's fund. Apparently, they were interested in discussing a Series B re-engagement for some other legal tech startup that had built an AI platform for contract analysis. I smiled and typed back, "We'll talk after Q2. Focus on sustainable business models first." The irony wasn't lost on me. 6 months ago, I'd been the useless father who didn't understand innovation or entrepreneurship or the transformative potential of artificial intelligence in legal services. Tonight, I was the guy that venture capital funds called when they needed advice about which legal tech investments might actually generate returns for their limited partners. In the quiet after the board meeting ended, Theo appeared in my study doorway wearing his pajamas and holding the rocket ship we'd colored during one of our first nights together after the custody arrangement. "Daddy, are we okay now?" he asked, the same question he'd been asking in different variations for months, each time with a little less worry and a little more confidence that the answer would be consistent. I answered the way I wish someone had answered me when I was 7 and trying to understand why adults made everything so complicated. "We are not perfect, Theo. We're honest. And honest is better than perfect." He nodded solemnly, the way kids do when they hear something that makes sense even if they don't fully understand why it's important. "Can we add more stars to the rocket tomorrow?" "As many as you want, buddy." After he went to bed, I stood on the penthouse terrace one more time, looking out at Manhattan's glittering circuit board of ambition and possibility. Somewhere in the city below, Maya was probably building her next company, applying the lessons she'd learned about the difference between venture capital and actual business fundamentals. Graham was probably on another private jet, heading to another conference where people discussed disruption and innovation instead of sustainable profit margins. But I didn't need to be anywhere else. I lit a single candle, left over from a birthday cake Theo and I had made together the previous month, and made a wish that had nothing to do with market domination or portfolio optimization or proving anyone wrong about anything. The door was locked because I chose to lock it. The company was steady because we'd built it properly. The child was safe because we'd prioritized his well-being over our own egos. And the noise, all the noise about who was right and who was wrong, about hostile takeovers and unconscionable debt enforcement, about useless fathers and impossible husbands. The noise was finally below us, where it belonged.